Well, that didn't take long. Judge Cameron McGowan Currie of the Eastern District of Virginia has already ruled that both the James Comey indictment and the Letitia James indictment were invalid because the U.S. attorney, the interim U.S. attorney Lindsay Halligan, was invalidly appointed. Let's take a look at what she has to say about this cluster. So here we are in the James Comey case, and the judge writes, on September 25th, Lindsay Halligan, a former White House aide with no prior prosecutorial experience, appeared before a federal grand jury in the Eastern District of Virginia. Having been appointed interim U.S. attorney by the Attorney General just days before, Ms. Halligan secured a 2-count indictment charging former FBI Director James B. Comey Jr. with making false statements to Congress and obstructing a congressional proceeding. Mr. Comey now moves to dismiss the indictment on the ground that Ms. Halligan, the sole prosecutor who presented the case to the grand jury, was unlawfully appointed in violation of 28 U.S.C. 546, you're going to hear that again, and the Constitution's Appointments Clause. As I explained below, I agree, and I will grant Mr. Comey's motion to dismiss without prejudice. The Appointments Clause prescribes the exclusive means of appointing officers of the United States. The text of the clause contemplates principal and inferior officers. Principal officers must be appointed by the President with the advice and consent of the Senate, but inferior officers can be appointed, and usually are appointed, by the President with the advice and consent of the Senate. However, 28 U.S.C. 546 allows for appointing an interim U.S. attorney when a vacancy arises. There's a procedure. The Attorney General may appoint someone for 120 days. After that 120 days, the District Court may appoint someone. On January 20th, Jessica Aber, nominated by President Biden and confirmed by the Senate, resigned as U.S. Attorney for the Eastern District of Virginia. The following day, the Attorney General appointed Eric Siebert as interim U.S. Attorney under Section 546. His 120-day appointment was set to expire on May 21st, but the District Court judges approved an extension or renewed his appointment. Mr. Siebert informed his colleagues of his resignation on September 19th, just after President Trump asked for his resignation, saying that he wanted Mr. Siebert out. Mr. Siebert, for his part, had expressed concerns to senior Department of Justice officials about the viability of pursuing charges against Mr. Comey and Letitia James. The next day, President Trump posted and later deleted the following message, which may have been meant to be a DM, publicly. Pam, I have reviewed over 30 statements and posts saying that essentially same old story as last time, all talk, no action. We've seen this before. What about Comey, Schiff, Letitia? Skipping ahead, they impeached me twice and indicted me 5 times over nothing. Justice must be served now. Less than 48 hours later, the Attorney General issued an order authorizing Lindsay Halligan to be the interim U.S. Attorney for the Eastern District of Virginia. That was on September 22nd. 3 days later, a grand jury sitting in the Eastern District of Virginia returned a 2-count indictment, which, if you saw the previous video, was originally a 3-count indictment and may have been the basis for a different motion to dismiss. That indictment charged Mr. Comey with making false statements and obstructing a congressional proceeding. Ms. Halligan was the only prosecutor who participated in the government's presentation to the grand jury, and only her signature appears on Mr. Comey's indictment. On October 20th, Mr. Comey moved to dismiss the indictment on the grounds that Ms. Halligan's appointment was unlawful. On October 21st, the Chief Judge designated me to consider this and any other motion, that's Judge Currie, and any other motion concerning the appointment, qualification, or disqualification of the United States Attorney for the U.S. Attorney's Office of the Eastern District of Virginia. Finding it necessary to determine the extent of Ms. Halligan's involvement, I ordered the government to submit for in-person review all documents related to Ms. Halligan's participation before the grand jury, along with complete transcripts. Upon reviewing the transcripts, I determined it did not include any remarks made by Ms. Halligan before and after the testimony of the sole witness. November 4th, I directed the government to submit a complete transcript and recording of all statements made by Ms. Halligan to the grand jury. In a notice, the government represented it had produced all materials. The government responded to Mr. Comey's motion, and they filed an order from the Attorney General attempting to ratify Ms. Halligan's appointment after the fact. Mr. Comey filed his reply November 10th, and there was a hearing on November 13th. During the hearing, the judge raised concerns about the Attorney General's ability to review Ms. Halligan's presentation to the grand jury when the government had not yet received the complete transcript of the proceeding just a few days earlier. I also noted that there appeared to be a gap in the grand jury transcript from 4:28 p.m. to 6:47 p.m. On November 14th, the government filed an unsworn declaration from Ms. Halligan and a new ratification order from the Attorney General. Ms. Halligan declared that the grand jury transcript accurately reflects the full extent of her appearance before the grand jury, and the period in question was solely the grand jury's private deliberations. She further stated there was no additional presentation, interaction, or discussion with the grand jury outside of what is reflected in the transcript. For her part, she stated she had reviewed the entirety of the record now available to the government and again ratified her actions before the grand jury and her signature on the indictment. Resolving Mr. Comey's motion requires me to first decide whether Ms. Halligan was validly appointed. If she was, I need not go any further. Mr. Comey's motion must be denied. If the answer is no, and Ms. Halligan had no authority to present Mr. Comey's indictment to the grand jury, then what remedy is appropriate? Should the indictment be dismissed, with or without prejudice? I'll address these issues below. According to the government, this case is simple. In its view, the one and only limitation on the Attorney General's authority is subsection B, which bars the Attorney General from appointing anyone whom the Senate refused to confirm. Nothing in the text, it continues, explicitly or implicitly, precludes the Attorney General from making multiple interim appointments during a vacancy. Thus, it concludes because the Senate has not refused advice and consent to Ms. Halligan, the Attorney General lawfully appointed her as an interim. Mr. Comey counters that Section 546 limits the tenure of the Attorney General's interim appointments to 120 days, and therefore precludes an additional appointment after that expiration. Mr. Siebert's appointment expired, therefore there isn't another slot available to be appointed by the Attorney General. The preeminent canon of statutory interpretation requires courts to presume that the legislature says in a statute what it means, and means in a statute what it says. Thus, my inquiry begins with the text, and ends there, if the text is unambiguous. The plainness or ambiguity of statutory language is determined by reference to the language itself, the specific context in which the language is used, and the broader context of the statute as a whole. Section 546 is unambiguous. Section A begins by authorizing the Attorney General to appoint a United States Attorney for the district in which the office of a USA is vacant. Subsection C2 imposes a time limit on appointments made by the Attorney General. A person appointed as U.S. Attorney under the statute may serve until the expiration of 120 days after the appointment by the Attorney General. Subsection D provides a single option for how subsequent appointments may be made. If an appointment expires under C2, the district court for such a district, and only the district court, may appoint a United States Attorney to serve until the vacancy is filled. The text and structure of subsection D in particular make clear the appointment power, 1, shifts to the district court after the 120-day period, and 2, does not revert to the Attorney General if a court-appointed U.S. Attorney leaves office before a Senate-confirmed U.S. Attorney is installed. The first word in subsection D, if, introduces a conditional clause that establishes the condition triggering the district court's authority. The indefinite article, an, points to a nonspecific thing, object, or person that is not distinguished from other members of a class. So the expiration of any single Attorney General appointment satisfies the condition. Thus, if, as here, a court-appointed U.S. Attorney resigns, the district court retains the authority to make another interim appointment because the triggering event, the expiration of an appointment under subsection C2, has already occurred. Finally, the conjunction until in subsection D's main clause defines the duration of the district court's authority. It lasts from the moment the condition is met up to the time that the vacancy is filled by a Senate-confirmed appointee. This reading is reinforced by the negative implication canon, which recognizes that the expression of one thing implies the exclusion of others. To be sure, the Supreme Court has cautioned that the force of any negative implication depends on context, and that the canon applies only when circumstances support a sensible inference that the term left out must have been meant to be excluded. Here, however, the inference is not just sensible, but overwhelming. Congress assigned the authority to appoint interim U.S. attorneys to different actors in different parts of the same statute. First to the Attorney General in subsection A, then to the District Court in subsection D. The omission of the Attorney General in subsection D, when combined with her inclusion in subsection A, is strong evidence Congress did not intend for the Attorney General to retain appointment power beyond 120 days. Adopting the government's contrary reading would render subsection D insignificant, leaving it to lie dormant in all but the most unlikely situations. Under the government's interpretation, the Attorney General appointees can serve indefinitely without Senate confirmation as long as the Attorney General revisits her interim appointments every 120 days. But if that were correct, the Attorney General could prevent interim appointments from ever expiring under subsection C2, which would in turn prevent the District Court from ever exercising its appointment power. Such a result would run counter to the principle that courts must avoid interpreting statutes in a way that has the practical effect of rendering a provision entirely superfluous in all but the most unusual circumstances. The government's interpretation also conflicts with Section 546's statutory history. From 1986 to 2006, Section 546 was identical to its current form. In 2006, Congress amended the statute to abolish the 120-day limit and the district court's backstopping role altogether. This change, which was inserted quietly into the conference report of the Reauthorization Act, the USA Patriot Improvement and Reauthorization Act, without debate made it possible for U.S. attorneys appointed on an interim basis to serve indefinitely. The switch to an unlimited appointment was short-lived. Congress reverted to the pre-Reauthorization Act language, reinstating the 120-day limit just a year later. In sum, the text, structure, and history of Section 546 point to one conclusion. The Attorney General's authority to appoint an interim U.S. attorney lasts for a total of 120 days from the date she first invokes Section 546. If the position remains vacant, the exclusive authority to make further interim appointments vests to the District Court, where it remains until the President's nominee is confirmed by the Senate. Ms. Halligan was not appointed in a manner consistent with this framework. The 120-day clock began running with Mr. Siebert's appointment January 21st. When that clock expired, so too did the Attorney General's appointment authority. So next, the judge discusses whether it should be dismissed with prejudice or without prejudice. With prejudice means the case and the claims would be dismissed forever. Double jeopardy would apply. The case could never be brought again under any circumstances. Without prejudice dismissal would normally mean the claims can be brought again. The case is dismissed, but a new case, starting from scratch, new indictment, new grand jury, could be brought again. Now, I don't think that has any major effect in this case because I believe the statute of limitations has already expired. So there would have to be a motion nunc pro tunc now for then to have charges recognized as before the statute of limitations expired. For some reason, I don't see how a judge would grant that, but that would have to be the way the government would proceed, to file a new indictment and then say that it's not outside the statute of limitations because of some reason. And the judge concludes that the dismissal will be without prejudice. Having found Ms. Halligan's appointment violated 546 and the Appointments Clause, and that dismissal is warranted, the remaining issue is whether the dismissal should be with or without prejudice. With prejudice, dismissals are an extreme remedy, and the judge believes that case law in both the Ryder and Lucia cases, which we did not go over, informs her that without prejudice dismissal is the appropriate remedy. So she concludes that Ms. Halligan was invalidly appointed, that her indicting Mr. Comey was an unlawful exercise of executive power, that the Attorney General's attempts to ratify Ms. Halligan's actions were ineffective, that Comey's motion to dismiss is granted, That's ECF number 60. The indictment is dismissed without prejudice, and the power to appoint an interim U.S. attorney for the Eastern District of Virginia during the current vacancy lies with the U.S. District Court and not with anyone else, the Attorney General, the President, etc. So that's Cameron McGowan Currie, United States senior United States District Judge, designated by the Fourth Circuit. And she writes the same thing in the Letitia James case. It's pretty much the exact same order, maybe a fewer pages because of the difference in the grand jury presentation, but still the same conclusion. The Letitia James case and the James Comey case are both dismissed without prejudice because of the shenanigans by the interim U.S. attorney. Well, I mean, technically, even though there were lots of shenanigans, that's not actually what undid the case. Like, sure, it would have if we got that far, but judges often want to use the easiest method of finding a resolution, so they'll triage. And in this case, the judge triaged the 4 motions to dismiss and said, like, hey, wait, if she's not appointed properly, this case is over. We don't have to analyze anything else. We don't have to do all that stuff with grand jury this and misconduct that and all that. If she's not validly appointed, done. So that's what the judge went with. So therefore, an invalid appointment means a person doesn't have the power they were appointed to have. So they are outside of their power. In Latin, we call it ultra vires. That's the legal term for it. And so her ultra vires actions are invalid. Cool. It's the right result. This is what should happen when vindictive prosecution actually occurs. It's ridiculous that the executive branch is weaponizing the law against its political enemies, people who criticize it, people who attempt to follow the law when the administration does not. So we live in fun, trying times that I'm looking forward to this being the before times, and then there being new after times. Let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney. I love you all. Have a great week. Have a great Thanksgiving.